All right, class, grab your seats and let's jump right in. Today's explainer is an absolute labor law masterclass, focusing on the Supreme Court's landmark April 2025 ruling in Aragones versus Alltech Biotech Corporation. If you're a law student, a practicing lawyer, or especially someone gearing up for the bar exams, you are going to want to take some very careful notes here. We're zeroing in on the exact fraction of a second the law actually recognizes an employment relationship and the absolute mess that happens when you get that timeline wrong. So, picture this. You crush your interviews for a premium corporate role. You're handed a dream job offer, and you sign it immediately. Prudent as you are, you hand in your resignation to your current firm to get ready for the big transition. But then, completely out of nowhere, before your first day even arrives, the new company pulls the offer. They claim your position was just abolished. Listen up, bar candidates, because this isn't just some cruel law school hypothetical. This is the exact factual matrix of the Aragones case. Here is our syllabus for today. First, the facts of the case, then perfection versus commencement, suspensive period versus condition, bypassing the fourfold test, why the redundancy defense failed, and finally, the key takeaways for the bar. Okay, Section 1, the facts of the case and the timeline of this withdrawn job offer. Here's exactly how it all went down. On April 1st, 2016, Alltech formally offered Paulo Aragones the role of Swine Technical Manager Pacific. Aragones unequivocally accepted, signed the offer on April 18th, and emailed it right back. Relying on that, he quit his job at Cargill. Now, his official start date was set for July 1st, but in May, Alltech's head office rolled out a global restructuring program, and on June 10th, weeks before he was even supposed to start, Alltech just withdrew the offer, claiming corporate redundancy.
Now, what's absolutely wild about this timeline is the total chaos it caused in the lower tribunals. I mean, the labor arbiter looked at it and said, yep, illegal dismissal. But then the NLRC literally completely reversed it. They claimed they didn't even have jurisdiction because Aragones wasn't technically an employee yet, since July 1st hadn't actually arrived. And the Court of Appeals, they agreed with the NLRC. This set the perfect stage for the Supreme Court to step in and school everyone on the law.
Moving to Section 2, perfection versus commencement, distinguishing contract formation from actual job execution. Let's put on our civil law hats for just a second here. Under the Civil Code, perfection of a contract needs three things: consent, an object certain, and a cause. It's the classic meeting of the minds. In this case, that meeting of the minds happened the exact millisecond Aragones emailed his signed acceptance back on April 18th. Boom. At that very second, the employment contract was perfectly formed. So, here is the absolutely crucial distinction. Perfection and commencement, they are not the same thing. The contract was locked in and the employer-employee relationship was established on April 18th. That July 1st date merely dictated when the actual demandability of those labor obligations kicked in. It's just scheduling when Aragones actually has to show up to work and when Alltech actually has to start paying him. All right, Section 3, suspensive period versus condition. Let's dig into why July 1st was definitely not a mere possibility. This right here is where law students constantly trip up, so pay attention. The lower courts basically got confused by older cases involving seafarers, where employment only begins upon actual departure from a port. Now, a ship leaving a port, that is a suspensive condition. It's a future, uncertain event. It might literally never happen. If the ship stays docked, the obligation doesn't exist. But July 1st, that is a day on the calendar, folks. It's a suspensive period. It is absolutely guaranteed to happen. And the Supreme Court hit the nail on the head by applying Civil Code Article 1193. Because July 1st was a certain period, it did not suspend the existence of the employment relationship. It merely deferred its demandability. The relationship was already rock solid way before Alltech sent that withdrawal letter on June 10th. You simply cannot unilaterally withdraw an offer that has already blossomed into a perfected contract. Section 4, bypassing the fourfold test. Let's talk about when our standard labor tests become entirely unnecessary. Normally, in almost every labor dispute where employment is questioned, what do? We rigidly apply the classic fourfold test: who hires, who pays, who fires, and the granddaddy of them all, who exercises the power of control. But here is the brilliant doctrinal twist from the Supreme Court. They tossed the fourfold test completely out the window for this specific scenario. Why? Because Alltech never actually denied offering the signed written contract to Aragones. You see, the fourfold test is really just an evidentiary tool. We use it when a relationship is denied, and we're forced to look at the messy facts on the ground. But when you have a clear, documented, admitted, and perfected contract sitting right in front of you, you don't need to overthink who was paying who just yet, because the contract itself proves the relationship already exists. Moving to Section 5, the redundancy defense failed. Why Alltech's corporate restructuring excuse totally fell apart. Now, we all know management prerogative allows a company to declare redundancy, but it's not some magic get-out-of-jail-free card. To legally pull it off, a company needs heavy, substantial evidence. The Supreme Court pointed to cases like Soriano and 3M, where employers brought receipts, detailed explanations of new tech, specific structural mergers, real data. Alltech, they just slapped down a single, super vague affidavit from a vice president. It had a bunch of generic buzzwords about shifting to local coverage, but literally zero operational details on why Aragones' exact, specific role had to go. Since their redundancy claim was basically made of Swiss cheese, the Supreme Court ruled the dismissal was flat out illegal. So Aragones gets separation pay, since going back to work there would be incredibly awkward, plus full back wages calculated from his original July 1st start date. Throw in 10% for attorney's fees and 6% legal interest. But take note here, no moral damages. The court basically said Alltech made a massive, terrible legal blunder, but they weren't acting out of pure malice or bad faith. Finally, Section 6. Key takeaways for the bar. Let's lock in the essential doctrinal principles from this case. All right, pencils ready, burn these 5 principles into your brain right now. 1. A signed, accepted offer instantly creates that employment relationship even before day 1. 2. Perfection of the contract is legally distinct from the commencement of work. 3, and this is the big one, a fixed start date on a calendar is a suspensive period, not a suspensive condition. 4. Don't blindly regurgitate the fourfold test if you already have an admitted written contract. And 5. If a company claims redundancy, they better bring a mountain of detailed proof, not just vague assertions. All right, court is adjourned. Seriously though, this ruling is a massive wake-up call for HR departments and corporate recruiters everywhere. How do you think this is going to change the way companies draft their job offers from now on? Are we going to see way more conditional language? Drop your thoughts down in the comments. I'd love to hear your take. And hey, if this explainer helped clear up your labor law outline, do me a huge favor. Like, comment, and subscribe to the channel for more deep dive case digests. Catch you all in the next one.